Hey there. Welcome back to the Remedy Report Newsroom. You guessed it. I'm your favorite host with the most, Giselle the She-Boss, coming to break you off with a little quality info for your mental. Finally, some news you can use as a tool. So, tonight we are talking about wheels, all right? Different types of wheels, what they're used for, what the purpose of them is, and um, pros and cons, and also the difference between a living will and a medical directive power of attorney. So, what is a will, you ask? And why do you need one? Well, a will, or also referred to as a last will and testament, is a legal document that describes how you would like your property and other assets to be distributed after your death. When you make a will, you can also use your children. You can choose to nominate guardians for your children, dependents, or your pets once you transition. Testator is one of them. A testator, that's the person who actually creates the will. Hence the last will and testament. Okay. So the next term you should be familiar with is executor, or sometimes referred to as executor, right? That's the person that the testator appoints to carry out their will, right? The next term you should be familiar with is beneficiaries. You might have also heard this term when it refers to trust, but lo and behold, wills also have beneficiaries too. Beneficiaries are the people or organizations who are left bequests, right? Which means cash gifts or other assets in the will by the testator. All right. And then the last term you should be familiar with is probate. Now, I'm sure you've heard of probate as far as a process that a will might have to go through if someone dies with a will, but they need to go through probate to have an executor appointed to operate over the trust, usually known as a testamentary trust, that someone has created while they were alive, but is only activated upon your transition. So probate. The probate is a judicial process where the will is proved in a court of law and accepted as a valid public document that is true in the last testament of the deceased, or whereby the estate is settled according to the laws of intestacy, right, in the state of residence of the deceased at the time of death in the absence of a legal will. So basically, what it's explaining is when a person dies with what they call a will, that means that they died with a will in testate, right? Meaning they had a will. When they die and they don't have a will, they call that having a will or dying with a will in intestate. All right. So the first word is intestate. There's two words, intestate. The second term is intestate, right? The first term, intestate, means that someone created a will while they were alive. They appointed an executor in that will to fulfill their wishes once they transition. And that will is only activated once they become deceased. But the person who has the will or that they left the will with has to go and file the will in court in order for the will to be proven as legitimate and legally standard and bound and sound, legally sound and binding, and proven that it is actually valid legally in order for them to officially appoint the executor and have the executor administrate over the estate's affairs. Now, if someone does not have a will when they pass, they consider that dying with the will in intestate. In that case, if there is an estate that has not been claimed or a will has not been created to express the wishes of the deceased, 9 times out of 10, that estate will have to go through probate, which could take a while, even years, and cost quite a bit of whatever was left in the estate, right? Because the estate will have to cover the cost of its own expenses if there were no provisions made or left or put in place to be able to make sure those things are actually adhered to. So if there is no will, anyone could become subject to having an executor appointed to oversee their estate when they're gone. And if your decedents or heirs or beneficiaries are not even aware that they are decedents, beneficiaries, or heirs to your estate, or that you did have a will that lists them, sometimes, things can happen where sometimes these lawyers get shady. They may not even let the people know, or they may not be able to get in contact with the heirs, the decedents, and beneficiaries. So it's important that you are aware of who you wish to leave things to, what your last wishes is, how you wish to see them carried out. And if anybody is involved in your will and they don't know, unless there's absolute reason to keep it a secret, at least make sure that their contact information and however they're able to be communicated with upon your deceasement is actually expressed and accurate, within your will. So the thing with the will is you may have to come and update your will every few years, right? That's something that may need to be done because things just change in life, and that's fine. You have the ability to do that. Also, another thing to remember is a will and a trust do not take the place of each other. Neither does one override the other, and neither is one more important than the other. They're actually different types of estate planning tools that can be used and put in place to actually work together and work cohesively, right? A will do things that a trust won't do, and a trust will do things that wills won't do. So wills is more so like your last wishes and what you want to see carried out as far as in your personal life. You may be things that you're leaving. It may be instructions you want. It could be, your funeral wishes or your desires for business. Maybe you need to have someone set up to look over your children. Things of that nature. You want to make sure that your will is really customized to your desires and your wishes. You don't want to use templates or a done for you process that does not express your true intentions and that align with what you actually want to happen for yourself and your heirs. Okay. And so a trust is created to usually protect assets. You can actually have the will protected within the trust. That's fine. Some people use what they call a pour over will. I've discussed this before. A pour over will is usually used in a structure like a life estate or a living trust, and it would basically pour over, or provisions would be made in there to pour over into a testamentary trust or irrevocable structure that does not activate until you transition. Also could be used to merge or collapse or dissolve a current standing trust into another trust as well upon your transition. So the pour over will kind of works as what they call a catch-all that'll catch things that are in limbo that you might not have put inside of your trust. A lot of people are easily able to transfer tangible assets into an irrevocable trust status structure, right? But sometimes you have other assets, or you might have other valuable things in your house or within your possession that you forget to list on the trust, or you may not have like a serial number or some type of unique identifying number that can specifically identify that asset on the schedule. So what you might do is use a pour over will to list like household things. You might, want to give your full wardrobe to your Aunt Betty, or something like that. Those are things that you may or may not actually have in your trust, especially if they're not maybe like name brand, high-end fashion. You don't necessarily still have tags or receipts for those items, but you may, see value in them. So you may want to list them in the will. You want to make sure that somebody who actually, who you feel like, you want to have actually have. A trust doesn't really get into those type of specifics. A trust lists what is held in trust, and it will also appoint and give authority to whoever is appointed as a trustee to oversee and manage those assets within the trust, as well as possibly dissolve and or liquidate, settle accounts and things of that nature. Whatever needs to be done to administrate over the estate, the affairs of the estate, once the person who actually created the will, once they transition.